Production and distribution of City Club forums on IdeaStream are made possible by the generous support of PNC and the Raskin Family Fund, with additional funding from Cleveland State University, Robert Conrad, and the Payne Fund.
Good evening and welcome to a special City Club of Cleveland forum. Tonight's program is part of our Anatomy of Justice series, presented in partnership with the Cleveland Metropolitan Bar Association. I want to thank all the members of the Cleveland Metro Bar who have assisted us with planning this program. Tonight we're taking a deeper look at plea bargaining and asking a very simple question: is justice being served? Let me say something about that question. It's not an idle question, and this isn't an academic exercise. Getting this right actually really does matter quite a lot to a lot of people. The overwhelming majority of cases that come before the Common Pleas Court in Cuyahoga County, and most courts really across the nation, wind up being decided in negotiated plea agreements. When these agreements are reached, we really are dispensing with the notion that people are innocent until proven guilty. Instead, everyone goes for a sure thing rather than a gamble. The prosecutor gets a conviction, the accused gets some sort of reduction in potential time, the court avoids a costly trial, and the public gains something, I suppose, but I'm not really sure what it is. The public depends on the criminal justice system more broadly to provide justice, to keep our communities safe and free from threats so that families can thrive and the economy can function. But what the public gets out of this is definitely a question for all of you and for our panel. Let me introduce our panel. We have representatives from various parts of the justice system. Saleh Awadallah is an assistant Cuyahoga County prosecutor. Mike Donnelly, Honorable Michael P. Donnelly of Cuyahoga County Common Pleas Court. Timothy Young is the director of the Office of the Ohio Public Defender, and Vicki Ward is local defense attorney. Our moderator is the Honorable John J. Russo, presiding and administrative judge in the Cuyahoga County Court of Common Pleas. And as I mentioned before we got started, too, that tonight's event will be a little different in format. We're going to start with the panel, and then we're going to include all of you in two ways. We'll have our usual Q&A, and we'll also be inviting you to join the conversation via Remesh. And if you're watching the live stream, you can join that conversation by going to remesh.chat/justice. That's remesh.chat/justice. Remesh is an engagement app produced by a Cleveland startup from the Flash Starts Accelerator. It'll give all of you an opportunity to simultaneously join the conversation and also respond to others' points of view and other contributions. And it's also anonymous, so it gives you an opportunity to lift up questions that you might not want to lift up yourself with a microphone in front of cameras and all that. I do want to recognize, too, that we have a lot of elected officials here today, judges and others, and I want to thank you for your service and thank you for your attendance tonight. So let's get started, ladies and gentlemen. Members and friends of the City Club of Cleveland and members and friends of the Cleveland Metropolitan Bar Association, please welcome our panel and our moderator.
All right, good evening, and thank you for being here this evening. An opportunity for all of us to hear from those who are in the trenches every day, who have an opportunity to, what we say, met out justice here in Cuyahoga County. The question before all of you is important, as it is for all of those who are sitting here with me. I'll be just the moderator. I'll ask for questions to be answered. I'll try to make sure that everybody has an opportunity to answer. Again, the dialogue from you is so important, so thank you for being here. I've asked Judge Donnelly if he would to have an opportunity to explain to all of you here, if you don't exactly know that process of how a plea happens, to give us an opportunity using a video with a few slides that he's just going to speak about generically about how a plea happens here in Cuyahoga County. So I'm going to ask Judge Donnelly to do that presentation first before we begin and dive into some questions with all those who are here. So thank you. Judge.
Thank you, Judge Russo, and thanks to all of you who responded to the invitation to be here tonight. Out of all the criminal justice reform initiatives that we've undertaken this year, I've been looking forward to this one the most. And that's because in 25 years in law, I cannot recall one instance where we're going to try to attempt what we're doing tonight, bring all the stakeholders together, judges, prosecutors, defense lawyers, victims advocates, those who represent the wrongfully convicted, and lift the shroud of mystery over a process that the public doesn't really know too much about. We're going to tell you a little bit how, in our planning sessions, we described how the sausage is made. And you're going to be able to respond on whether you like what you see. Our Supreme Commander, Dan, has given me 5 minutes to explain this process, so let's get underway. How prevalent is plea bargaining?
You've got 2 minutes.
Okay. I'll speed it up. How prevalent is plea bargaining in our process? Well, here's some statistics from the prosecutor's office. The most recent that I had when I completed this came from 2014. To say that plea bargaining is prevalent would be the ultimate understatement. Plea bargaining ultimately dominates what we do in the criminal justice system to resolve criminal disputes. As you'll see in the first slide, 10,590 indictments came out of Cuyahoga County Grand Jury in 2014 alone. What happened to those cases? 97% of all cases were resolved through plea agreement or diversion, etc. How about the cases that went to trial? We all see the movies and watch justice taking place in the movies through dramatic cross-examinations at trial. In reality, only 305 cases proceeded to trial out of those 10,000 in 2014. As you'll see, the prosecutors has a good record in terms of obtaining a conviction on the cases that they go forward on trial. 71% of those cases received a guilty conviction, and 29% ended up in not guilty verdicts. Why are we doing this tonight? As I said before, very few people know about what takes place in the intricacies of plea negotiation. So transparency, as I've found over the years on 12 years on the bench, I believe is the single most important factor in ensuring the justice system is working as designed. Your ability as the public that we serve to be able to determine how we resolve these cases, and are these resolutions in the interest of justice for everyone. Right now I'm going to show you a timeline that represents the lifespan of a criminal dispute, whether it concerns the most heinous criminal conduct in our society, from murder, rape, aggravated burglary, all the way down to the more relatively mundane traffic violations, speeding violations. But we're going to focus on felonies for this particular slide. And I'll demonstrate that a criminal dispute starts in the grand jury. As many of the practitioners know, the prosecutors present charges that they believe they have evidence to support are true. They present it to a grand jury, and this is a check on the system where the grand jury decides whether there's probable cause. Is the suspect more likely than not guilty of the charge that is being presented? If they agree yes, they issue a true bill indictment, and then we move to the next stage of the process, which is the accused receiving notice that they have been accused and the requirement that they respond to that. That occurs at the arraignment. Now, at the arraignment, usually this occurs very shortly, and they only have 24 hours to respond to these charges. Generally, for the most part, people do not have attorneys. If they do, they've just been retained. 99.9% of the time at the arraignment, the plea that is going to be entered by the accused is a not guilty plea. In 12 years on the bench, I've only seen it one time in the arraignment room that someone came in and pled guilty. So they plead not guilty, and there's good reasons for that, as the defense lawyers in this room know. They haven't heard what the evidence is. They don't know what supports the charges. They haven't explored defenses. So they need to do that before they can find out. But this is the creation of a criminal dispute. So what's the purpose of the criminal justice system at this stage? It's to find out what's the truth. I believe that's what the public believes. So how do we do this? We set a pretrial. The case is assigned to one of the 34 judges in Cuyahoga County, and we bring the accuser and the accused together and require that they provide each other information. The government must turn over all the information they have that they believe that supports the truthfulness of those charges. And in addition, because prosecutors are ministers of justice, they have to provide other information too. Information that the practitioners known as Brady material that might, say for instance, mitigate or exculpate or not fit in line with their direct theory of the guilt of the defendant. This is required to be turned over because prosecutors are there to do justice, not to just receive conviction. The process is reciprocal in that the defense has to turn over their information as well. What's the steam that runs the engine? What's the fuel? Well, that's controlled by the court. When the court sets at that pretrial, our most important tool in bringing these cases to a resolution, and that's a trial date certain. That places in the mind of the accuser and the accused the certainty that they must start preparing for trial. They must explore the facts, try to get a hold on what the truth is behind the accusation, explore defenses, because they know what's going to take place at that trial date. One of three things. The state's going to go forward and prove those charges beyond a reasonable doubt, a standard that protects us all, a very high standard. The case is going to be dismissed by the court if the parties aren't prepared to go forward. Or the prosecutor may choose to dismiss the case themselves. Or three, they may present the court with a plea agreement. What are the elements of a plea agreement for those of you who don't practice? This is how I would describe an ethical plea agreement. It's a contract, a legally enforceable contract, in which the government extends a benefit to the accused. Now, that benefit is going to come in many forms depending on what the case is. It could be in the dropping of charges, limiting the defendant's criminal liability. It might be lowering the form of the offense to a legally recognized lower form of the offense, or it might be a position towards sentencing. This is all done after the prosecutor has properly considered whether, number one, in their discretion, do they want to prosecute to the fullest extent of the law, or are there factors here that they can consider to use restraint and not process to the fullest extent of the law? What does the government in exchange receive? They receive an admission to the charge that's presented, and in so doing, receive accountability for criminal activity which actually occurred. And that's the plea bargaining process, and I probably went over time. I apologize.
That's all right. That's great. Thank you. Judge Russo.
So why don't I ask, I'll ask Saul first from the prosecutor's office. So what do you see yourself the role? Judge Donnelly, all of us were aware of the slides, kind of the presentation, but where do you see the prosecutor in the role as outlined in this plea bargaining process?
Well, thanks, Judge. Well, as the prosecutor, we're, after the grand jury indictment, we're presenting the facts, and we are the advocates. We are the moving party. So we are, when we get to the case, now Judge Donnelly started at the grand jury, and I'll tell you, context is very important in this, because this is the 10,000 cases are what came out of the grand jury. There's a lot of other cases that happen out in the community that never, make it into the criminal justice system as you have defined it. Plenty of crimes happen that don't get reported, aren't investigated thoroughly, and don't actually make it down. And those that make it down, there's another culling and narrowing factor in that. So what you're seeing here are a lot of narrowing factors that get into the grand jury, and then those that survive the grand jury then move on, and the cases are assigned to an assistant prosecutor to pursue the case and to look at the facts and the factors of the case and prosecute the case, prepare the case for trial, get a trial date, and move and prepare your case for trial. In preparing your case for trial, a lot of things will happen, and one of those things is either you go to trial, or there's a resolution, or there's a dismissal of the case. Sometimes the case we see at the beginning is the same case we see in the middle, the same case we see at the end. But oftentimes, sometimes they get better, sometimes they get worse. And as we travel down that road of the criminal justice system in the court, we take appropriate action to resolve the matter.
Tim, how about yourself? You represent the state of Ohio in the public defenders, being their spokesperson as well as overseeing the public defenders here. Our public defender, Mark Stanton, is here as well. And so I ask, what's the role that the public defender would play in the process of the plea bargain as Judge Donnelly has outlined?
We defend the individual and fundamentally defend the Constitution, the Bill of Rights, the founders' most fundamental ideals. As expressed in those Bill of Rights, were all individual rights given to people to protect themselves from the overreach and the fairly awesome power of the government when it wants to bring it against a single individual. Our job is to stand between the government and that individual. And today, that dynamic is far different from what started when our founders set up this system of public trials and the right to counsel and the right to a fair trial. We started in a system where we were more evenly matched and almost every case went to trial. Today, with no disrespect intended to any judge in the room, the most powerful person in the room is the prosecutor today and has been for decades. The constant upping of charges, the double, triple charging for one crime, the mandatory sentencing, the collateral consequences that keep getting added on, and ultimately what we have turned our process into, and the unfortunate reality, at least in my 25-year career defending people, is the most common conversation I have isn't about truth and justice anymore. It's about risk-benefit. And I wish it were about truth and justice, but so often it's about the risk and the benefit and respectfully, what rights my client now has to walk away from that the founders thought he should have.
Vicki Ward, a very prominent defense lawyer here in Cuyahoga County. Vicki, collateral consequences, as Tim Young just pointed out. So the collateral consequences, where do you find your role either as an assigned defense lawyer and or a retained defense lawyer here in Cuyahoga County when working through the process as described to get to either a plea bargain and justice?
Well, so anymore, we have to be familiar with collateral consequences when we are attempting to resolve the case for our clients. And I agree with Mr. Young that truth and justice is it's almost a unattainable type of focus because it is risk management. I'm advising my client what the risk is if he goes to trial versus a plea bargain. We do, as Saul said, investigate, weigh the evidence, and begin negotiating with the prosecutor to obtain a good plea bargain. And it's even more difficult in the federal system. Now we have to also look into the collateral consequences. Of course, for so many, you lose your right to vote. You can't hold a state license to become a barber or a cosmetologist. You have to wait so many years to do certain things. You can't work in the nursing industry if you have certain particular convictions. Certain offenses aren't expungible. And so these collateral consequences continue to grow over the years. And then we're charged with knowing what those are, advising our clients of those, and again, the resolution 9 times out of 10 is some sort of plea bargain. And the federal system, it's even less.
Can I ask a quick question? Do any of you believe the current system is a good system?
Judge Donnelly?
I mean, I believe when everyone's doing their job right, I mean, it's been a privilege for 12 years to watch hardworking prosecutors and defense lawyers, both of which play an equal role in the process of justice. When everyone's doing their job right, including the judge being neutral, I believe the process of plea bargaining most often produces just results. So there's a lot of good things that take place if everything's kept in check and everybody's doing their job right. It's when people go astray from the ultimate goal of truth and accountability.
Of the, I don't know how many cases you see. You see hundreds of cases a year. What's the percentage where you believe everybody's doing great? Obviously, in all of them, the judge is doing great. We know that.
Yeah. You know, I spend most of my time not in trial. I spend out in the courtroom discussing plea agreements. And oftentimes it's after both sides have done their due diligence. They've discussed the case with their client, the accused. They've discussed with the victim, and they produce results that achieve what I talked about before, some level of accountability, so we can move on to the sentencing phase.
So if I could ask, I mean, so Tim Young just boosted you as the most powerful person in the room.
Is that where I'm sitting?
That's why you're sitting there. You're the power. But really, Tim said, hey, really, all of this rests in the hands of the prosecution. Do you believe in that, or do you believe, as Judge Donnelly said, there's this justice being meted out where everybody is being actively involved?
Yeah.
But
Yeah,
right now,
let me just say
you're
this.
the power.
Yeah, Judge, let me just say this. You know, the numbers on the indictments, the 10,000, these don't magically appear. You know, somebody had to commit a crime, or a crime had to occur out in the public in order for us to know about it. I mean, we just don't make up pieces of paper and say, let's go and pick somebody out and prosecute them. You know, there's a crime that happens, an investigation that takes place, and then a prosecution. And again, the question is, you know, is this a good system? I mean, during voir dire, it's not a perfect system, but name me another system that you'd rather have than to be able to have a jury and or bench trial and advocate or and have your case heard by 12 people who know nothing about the matter, don't know the participants, and will listen to the facts and be the judges of the facts.
I think Ms. Ward has something to say.
Yeah, I think both Tim, I saw a little sigh out of both of you. But
You know, that's a nice theory. Something occurred out in the community. Many times, it's not the person that we're representing. That happens on occasion. And someone mentioned that an indictment may have, there's one crime usually and an indictment with 15 or 20 charges on it. For instance, if you are accused of robbing someone, they throw kidnapping on there, which in many times that's a legal fiction, but you still got to defend that. So somebody did something, went to the grand jury, which that's a whole nother conversation. The grand jury and how that works in an indictment. But the fact that it's a crime committed and now we're here, somebody did something, and basically I believe Saul said the defendant did something, which
Somebody did something.
Somebody did something.
somebody did something.
Yeah. So it's not a, you know,
But
the act is not a legal
Can I
fiction.
ask a pointed question of you, Saul?
Yes.
Does it matter? Somebody did something, and Judge Donnelly, you said that in your presentation, you noted that somebody is held accountable, or there's accountability, right? How confident are you that the person who's pleading guilty is the person who did the crime?
Are you asking me?
Yes.
Listen, I sit here, now we're in the middle here, but I have a dual purpose here. I don't, we're, not only are we, prosecuting the case, but we're, and pursuing the guilty, but we're trying to protect the innocent as well. We have a, as ministers of justice, our duty is not just to advocate for one particular person. My colleagues here, I mean, they have a, they talk, and they do in terms of the Constitution, but their main mission is their clients' benefit, their clients' rights, their clients' best interest. I have the best interests of the public in general and of the justice. And as I pursue a case, I have to make sure and be confident in that person committed that particular crime at a particular time and place. I mean, I have to be absolutely confident, and that's why we pursue the cases. And again, our justice system has 12 people who can figure out the facts, cross-examination, tested those facts. I mean.
Let me say, in a second, we're going to go to the Remesh app so you can answer a few questions and participate. If you haven't yet logged on, just grab your phone, go to remesh.chat/justice, and because we're going to engage you all in a few questions in a second. I think that
Tim, I think you wanted to add to that.
I do. You asked, and I cycle us back to your question, do I think the system's a good system? And I think if you look at mass incarceration in America, and you look at the huge racial disparities in who we prosecute and how we sentence, that you can't come to the conclusion that it's a good system.
People then ask, well, why do you work in it? Because I think the system can be good. I think those fundamental, I really do believe in what I said, the founders' ideals, the Bill of Rights, those are magical words. If we upheld them, if we didn't spend our days in courtrooms fighting against prosecutors who unfortunately most of the time are trying to chip away at your Fourth Amendment rights or your right to an appeal of your sentence or your right that has been granted to you by the founders, that the main person in our justice system who is constantly saying and arguing against the expansion of those rights or the protection of those rights is the government. I think the system could be great, but we lost our way. And our numbers and 2.2 million people in prison show us we lost our way.
Judge?
Before you go to your question?
Yeah,
Okay.
one, yes.
I wanted to mention, for those people that don't know this fact, that the rules that govern prosecutors in their prosecution, Rule 3.8 states that a prosecutor is prohibited from seeking a conviction on any case where they know there's not probable cause. Now, when you think about that standard, every prosecutor that receives a file from the grand jury has that assurance right there. But what do we know in the process, as was alluded to before? From that point up into the trial point, they either receive information that adds to or enhances their belief in the guilt of the defendant, or may detract from it. I have always advocated that there be a good faith rule, that prosecutors must at all times, based on the information that they receive, have a good faith belief that they're prosecuting someone who's actually guilty of what they've been charged with. I spoke to the Ohio Prosecuting Attorneys Association, and I said to the room full of 400 prosecutors, who believes that this is important? All of them raised their hands. When I said, shouldn't that be built into the rules? Half the hands went down. Maybe not the rules. But I've said this before, it sounds funny, but one of the most teaching moments in our movies, and I know a lot of you like legal movies, comes from My Cousin Vinny. Because what happens in My Cousin Vinny when they receive information that leads them to believe they're prosecuting the wrong guy? The prosecutor doesn't turn and say, how would you like a misdemeanor? He says, Your Honor, we dismiss all charges. And there should be no shame in that. There should be no stigma in dismissing charges when you've lost your good faith belief in the guilt of the defendant.
Dan, you have a question from Ramesh?
Yeah, well, let's go to the audience right now. We're going to go to so if you're not on your phone, get on your phone. There's a time you can be on your phone. You're allowed to be on your phone. So remesh.chat/justice. And the first question there is for all of you. It's a poll. Like, do you think the system is working well? So we're going to just take a quiet minute, and you're going to, even the judges in the room are going to pull out their phones and do this. And there's a couple of questions after that as well about what you think is working well and the concerns that you have, and then we'll take a look at the answers. You can see it on your phone too, Judge.
Okay. I turned mine off so it didn't interrupt. Are we supposed to look at the results?
Technology.
So are we there, Aaron? How many people are participating? 46? So we have about 100 people in the room. 46 of you are participating. The other ones will have to negotiate a bargain on your way out the door. Get your phones out, people.
If you get out the door,
Yeah.
we won't let you.
Yes. Remesh.chat/justice, and you can find it on your printed program. Sabod's holding it up really high so you can see it, right there at the bottom. And after you answer the question, it'll present you with other responses from other people in the room, and you can decide which one you have more affinity with. I know you just turned your phone off before, but you can turn it back on. Really?
Joe,
While doing that, may I follow
Yeah,
up
go
on
ahead.
the judge's
You can
comment?
say another
I
word.
was going to ask a question.
Yeah.
Very quickly, I don't disagree with those are the duties of the prosecutor, but I find it really interesting that there's a national trend on innocence cases that the prosecutors aren't standing up anymore and saying, we dismiss all charges.
Instead, they're asking for Alford pleas, pleas where the client says, I'm not guilty, I didn't do this crime, but because the deal is so good, like 30 more days on a life sentence before I go free, real case, just happened in Franklin County, a man serving a sentence for a crime that never happened, his wife committed suicide, and instead of dismissing, and this is with the coroner reversing the death verdict, that there was no homicide, that they ask for 30 more days in a plea to protect their liability. I assume it's to protect their liability from a further civil lawsuit. And that's just one example. A case recently in Cleveland happened where they asked for 4 more years on a case where they didn't have any arson science to support the finding of arson anymore. There just wasn't any, they didn't have an expert who could support and say arson happened and therefore there was actually a homicide in these cases. It's not uncommon, and those are just Ohio examples, but there's been this national trend lately that these conviction integrity units that are lauded throughout the country are really more about making sure that conviction stays rather than that it has integrity. And that's a depressing fact, that we are trending towards this outcome of not the truth, but some fake plea. The sausage keeps getting made, and now even when we know they're innocent, we keep making the sausage.
Let's go to Dan.
I just want to point out that 61% of you believe the system's not working.
Not working.
Not working.
Well, my work here is done.
30% said yes, and 9% said not sure. So that's kind of interesting. We can get deeper into the details, but I'm going to go back to the poll. 57 of you are now online, so thanks to those of you who have changed your mind and decided to participate. It's much more fun, I think, to participate. All right. Did you have a
Yes, I do. Okay, so let's do this because a lot pointed right at Saul and the prosecutors in the state, or outside the state. So let me ask this question. There are resolves to cases, plea bargains, 97%. But there's two sides, right, for all of us here. The prosecutor may be making an offer or maybe discussing a plea, but there's a defense lawyer. There's a Vicki Ward and there's a Tim Young on the other side with their client accepting the plea. And so the question is, moving that to both sides of the table, Judge Donnelly has mentioned these baseless pleas, some discussions of baseless pleas. I'll let him tell a little bit about his thoughts on baseless pleas, but then I want to hear from the defense. I want to hear from the defense about why do you accept baseless pleas or maybe factually baseless pleas, or do you not, or do you feel like you're cornered? Do you feel, maybe as Tim said, that the muscle sits in the nest of the prosecutor? So, Judge Donnelly, if you would, just briefly, you've spoken publicly about it, you've written about it, factually baseless pleas in your eyes. Can you explain to those who may not totally understand briefly what that is in your thought process? And then I'll let all the others comment as well.
Thank you. Yes, it's a phenomenon that occurs not just here in Cuyahoga County, but across the country. It's been outlawed in the federal system. They require a factual basis. I'm not saying that the federal system doesn't have its own problems, but factually baseless pleas, for those who don't understand it, is specifically allowing the accused to resolve their case by pleading to a crime that everyone in the room knows they did not commit. And I have 3 law students here at my table, both from Cleveland Marshall, Maya, Grace, and Dan, who helped me out over the last course of the years. We looked at this. This seems to occur at the felony level, particularly in sexual assault cases. And over the last couple of years, I've looked at all the pleas that came, or the charges that came in as sexual assault cases that went out as non-sex cases. And we found some really alarming results. In one case, we found someone who was charged with 46 counts of downloading child pornography, with 1 count of possession of criminal tools that presumably dealt with a computer that the person used in that case. That's all the charges were. Now, these are serious charges. Some people are serving lots and lots of times for convictions on this. Now, in this particular case that we looked at, they didn't resolve with dismissing some of the charges. They resolved that case by allowing that defendant to plead to the crime of felonious assault, and he was placed on probation. And that raises questions. Why was that plea offered? What happened? Was there any facts to support?
Not only offered, Judge, but why was it accepted? Why did Tim Young or Vicki Ward say to their client, let's accept that plea?
It's a not, well, I'll let Tim go this, because I agree with him, because we tried to advance a rule with the Ohio Supreme Court 2 years ago, and it was rejected without comment, and that speaks volumes, without comment, because if you're going to reject something, you'd think you'd have a reason. And all it would require is, if a plea is presented to me that doesn't seem to resemble what was originally accused, I'm just going to turn on the record and say, Mr. or Madam Prosecutor, can you tell me facts that, if true, support what the accused is going to be admitting to? Then I know what took place.
Yes. Let me just put the conversation on pause for a second and ask you too. Like, I'll come back to this in a moment, but we got some really great responses on what's working well about the system. Now you're invited to tell us what your concerns are. Obviously, factually basis pleas might be one of those concerns, but we've got a few people on there right now. But if you want to add your concerns, this is the opportunity to do so. But go ahead, Tim Young.
Tim, I'll go to you. So you talk about the muscle. You tell Saul he's running the show, but yet when the show comes to you or to Vicki, I mean, there's that plea. Somebody accepted that plea of felonious assault, as opposed to maybe the evidence wasn't there. I don't know anything about the case. That maybe you should have went to trial and got the not guilty plea or the dismissal. I don't know. But what happens and why do you do that?
The question of why is exactly the question to be asking. Why would you do that? And you have to start at the beginning of, where did the process break? It didn't break at the moment that we're asking whether this is a factually true plea or not. That's the end of the process. This process was corrupted way back at the beginning, back when we had mandatory sentencing that we can't get out from under. And the prosecutor doesn't have any discretion to waive that mandatory time. This is handed to them from the legislature, who have decided to take away discretion from everybody, that this crime must go to prison for X number of years, every single time, regardless of any mitigating factors there might be. Or this crime, what we used to think that once people had served their time and paid their debt to society, they could get along with their lives. Not anymore. Collateral consequences are the scarlet letter for the rest of your life. And most of them, well, not most, many of them are completely pointless. People believe strongly in these lists of sexual offenders and registration lists and notifications. There isn't a shred of evidence that prove that they provide public safety to anyone, anywhere, and in fact, a few studies suggest that they actually cause our society more danger, because people trying to avoid these registration lists or being homeless and destabilized are far more likely to commit another crime and not be reported on these registration lists. So you've got all of these factors that were broken at the beginning of the system, long before we get to the plea. Getting a factually truthful plea is fine if you had a system that hadn't broken it before you got there. And respectfully, Judge Donnelly, it's cart before the horse. You got to fix all of that at the beginning before you get to this piece. You can get to truthful pleas. We really could achieve that in our system if we got rid of all of the junk that has forced us into these decisions. Why would a person plead to a felonious assault on 30 counts of downloading kiddie porn? Maybe the case was really weak. Maybe there was a Fourth Amendment problem with the search that the prosecutor didn't want to risk losing the whole case. Maybe their factual basis for the case, they really couldn't prove he downloaded it specifically. Other people had access to the computer. But he doesn't want to risk going to trial and getting maxed and stacked with mandatory time for 30 or 40 years of his life with a registration for the rest of his life. And maybe he didn't do it. Controlling an outcome of that's the risk benefit. I go in and talk with a client and say, this isn't about whether you did it anymore. It's about whether you walk out the door tomorrow.
So, Saul, obviously an opportunity to digest a little bit of this. I mean, Judge Donnelly is speaking about the opportunity of prosecutors to be able to walk away and dismiss a case. Tim mentions evidence may not be there, it may not be the right person, dismiss the case. And then you have this.
Yeah, I've dismissed my fair share of cases over the years. So it's not about just if I don't believe in the case, we'll dismiss it. Just this past year, we had a motion for new trial, your conviction integrity, issue. where we went back, we looked at the science changed from the time that the individual, we had a trial back in the 90s, and we looked at the science, and it changed. So we went back and proactively asked the judge to release the gentleman, pending further testing, and we'll still you have to resolve the case. But we made that proactive step. I mean, last year we did the same thing with the Bridgman brothers and Mr. Jackson in another case where we proactively said, look, we don't have confidence in this conviction anymore. If I don't have confidence in the conviction anymore, then I'm going to tell my boss and my supervisor, I don't have confidence in the conviction.
But bring it forward, if you would. I mean, so when you get the indictment, you have the police who did their investigation. Now the indictment comes from the grand jury, and now you're at that stage. We're talking about individuals like Joe and others who've served 20 plus years in prison, and now the conviction's overturned. And those are things that are important. But what about up front, as Tim's saying? Tim's saying that the process is broken up front. Do you believe that?
No.
No.
I mean, the process is not perfect, but everybody here takes a mirror and looks at themselves in the mirror, because we're all part of the process. We all vote for our legislatures. We all participate in the process one way or the other. You each will hopefully be called in for jury duty, either grand jury duty or the petit jury. We are all part of the process. So we all have to be part of the solution here, but it's not this process out of context with everything. So if we're not ready to improve the process, then it really, it needs improvement. Of course, nothing's perfect.
Vicki,
This case
right
here,
ahead.
though, the defense came and asked for that particular plea. And it's just, so there's a defense, there's a prosecutor, and there's a judge. There's three parties involved in this thing. So at some point, somebody looked at the case, the facts, whether they, again, like I said, so we have a view of the facts initially, and as the pretrials and as the defense does their duty, their diligence, and they try to poke holes in our case, again, it might get worse, it might stay the same, it might get better. But at that point, the defendants asked for that mark, and there was a discussion had between that prosecutor who had the case, their supervisor, and a decision was made to go ahead and offer that plea because of the ask. Again, it went before a judge, and the judge accepted that plea. A judge has a power to reject any guilty plea they want. It's already built into the rules. So you had the three parties involved in that case.
Dan, I'm going to give Vicki a chance to speak, and then I think
I
we're
wanna
going to go to
share-
some questions with everybody.
Share what's been
Just your
shared.
thoughts.
I'm going to be brief because, again, Mr. Young has pretty much set out the exact way this goes. Particularly in the federal system, the risks of going to trial versus a plea bargain is massive.
And that's because of their sentencing
It's
guidelines.
because of the sentencing guidelines. There's the guideline sentence that you know what it's going to be when you enter into a plea agreement.
what do you think
and
about-
then the statutory time, which is sometimes 2 to 3 times more than what that is in the sentencing guidelines. So our discussion with the client is, would you rather do 12 years or would you rather do 25? It's about how much time you're going to
And
do.
you say that similar discussion in the federal is still done here in the common pleas. You're still talking about the risk of time, the risk of losing, versus I know the end result. It's a felonious assault. I'm gonna get less opportunity of jail sentence than I would with 54 counts of child pornography.
In many instances, if I have a felonious assault and they offer a misdemeanor, while the case probably should be dismissed, and there are a lot of defense attorneys in this room, I'm not sure how many of you have received a dismissal in the past, well, just this year, or maybe in the past year. You want to show your hand. A dismissal is not very common.
Okay.
You will, instead of pleading as F2, would you like a misdemeanor? When I would love to get it dismissed, I'm arguing vehemently to get it dismissed. What's the likelihood? That's another.
Okay. Dan,
I want to.
go ahead.
Then there's the trial.
Exactly.
Then there's the 12 people.
Exactly.
That's
So you try a case
and then
when there's a misdemeanor involved.
Well, no, I mean, in
that's
terms of
not
the
realistic, Saul. Come on.
But in terms of felonious assault, we just had a case this past week where diversion was talked about, and for whatever reason, it was rejected, and he went to trial, and he was convicted of a felony of the second degree.
Right.
I mean,
Well,
that's
But you had the factual basis
There's
because the
the
jury
point.
came back with the guilty.
Exactly. And so,
So
if you don't think you have a factual basis, then you could take it to trial.
In your example, you did exactly what Judge Donnelly said. You followed the code. You had a facts that fit the crime. You did offer a possibility of a resolve, but you went forward with the trial and was convicted.
That's fine.
So you did your job as the prosecutor.
We carry the burden. You know, if we are, the burden's on us. We have to move forward. We're the moving party. If you put us to our test and we have to move, we either have to produce the evidence, you know, prosecute the case, or dismiss the case.
Very good. Dan.
We've had some very interesting responses from all of you, and I want to share some of them with the panel because you guys can't see what everybody else has been sharing. But on this question of what concerns you, we had the first question was what's working right, and there were a few things. I don't want to spend a lot of time there because I think our conversation has really shifted to what are the problems, how can we fix them. So here are some of the top concerns that the audience has raised. I want to start with number 5. There's a bunch of them, but I'll just do the top 5. Number 5, victims are an afterthought in the process. We need to talk about victims. Number 4, overzealous prosecutors are interested more in winning than in justice. They're interested more in winning than justice, sorry. Number 3, disparity of treatment is based upon zip code, race, and bank account. Number 2, judicial interference with a negotiated plea, mandatory sentencing, mandatory collateral effects like sex offense registration for life. We've talked about that. And the top response was that the police and prosecutors often overreach and forget their roles if defending truth and justice, not merely winning. And the inadequacy of defense counsel for defendants, particularly in appointed counsel. Why don't we start with the victims, because we haven't talked about victims at all, and then I'd like to hear panelists address that top response too.
Okay, so we'll go with the victims, and Saul, it starts with you, as you said. I mean, you have a dual role, and that role is played out every day in the courtroom, but you gave us a vision of outside of that. I mean, it's much more than that. I mean, it starts even before we get in the room of a grand jury, and you gave us a little picture of there's much more before that happens, and even in cases that we never see because of your continuing working as the prosecutor. So where does the victim play a role, and how important is that to you in bringing a case forward?
Well, I mean, the victim is actually obviously central to the ongoing dispute here, the ongoing issue. In rape cases and felonious assault cases and in other cases, is always a victim. And while we, you know, again, we're pursuing the case, making sure that we pursue the case to the fullest extent for the grieved party, but we also have to make sure that we're doing so protecting, you know, the rights of everybody involved. You know, you talk collateral consequences of, you know, of a conviction. You know, we can spend a whole session here talking about the consequences to a victim that they have to live with, you know, going forward with what act happened to them. But of course, they're central in the decision-making process. Their input is taken and given serious consideration. But at the end of the day, it's a decision that our office, has to make in resolving the case. Sometimes the victims want, you know, less time. Sometimes they want more. But we have to make sure that we're even-handed across the board. Attempt to be even-handed across the board for justice' sake. Very
good, Judge Donnelly. We deal with it every day. It's one of the factors we take included in sentencing. What are your thoughts about how the victims play a role in the plea process?
Victim impact is very important to the process when trying to determine a just sentence. But I do believe that the victim should be brought in more into the plea bargaining process and explained exactly what is taking place and what, if it's going to be a plea, what the accused is taking responsibility for. Let me give you an example. In Cuyahoga County, and all rape cases generally that I see, it's a charge of rape and then there's a charge of kidnapping. And if you were to ask the prosecutor on the record, what's the factual basis for the kidnapping? Most likely than not, they would say, well, when the person was in the act of raping the person, they were restraining them of their liberty. Now, if a plea drops the rape charge and reduces that kidnapping to a lower form of the kidnapping offense and offers the defendant abduction to plea, what's not taking place is an inquiry on the record with the prosecutor. What are the facts that, if true, support that abduction? So that the victim who's sitting in the courtroom watching that plea can say, well, when the person was sexually assaulting the person, they were restraining them their liberty. Then the defendant, who's accepting that plea and supposed to be admitting to something, knows exactly what they're admitting to, and the judge knows what they're sentencing on if they agree to accept that plea. And we've talked about judges. They always have the opportunity to reject pleas. I don't believe the law provides any instruction to the courts about how they should use that discretion. Some judges can just say, I don't like it, it's not strong enough. They can use various reasons, and if the plea is taken up to the Court of Appeals, they view it on abuse of discretion. They're very deferential to the trial courts. And so it's very hard to get a plea overturned at the appellate court level. I believe Rule 11 would give courts direction on how to use that discretion properly. Just one step towards reform.
Tim, why don't you, if you could just speak for you and Vicki overall, the role of the victim with you trying to resolve a case, research a case, where do you find the importance? Do you believe they're representative? Do you have access to discussions with victims, statements and things of that sort? Or do you think there's something missing for the defense of clients who are accused by a victim?
Let me start with the full disclosure. I am the official opposition to Marsy's Law in Ohio. I was appointed by the Senate President and the Speaker of the House to oppose Marsy's Law, which is a victim's right amendment. I want to also make sure you understand I am not opposed to victims' rights. I'm opposed to what that constitutional amendment says and what it will do to our justice system.
And I'll just jump in to say, too, the judges in the state of Ohio are also having opposition. So those of you, for the same reasons, that we believe that it overreaches, but that there are currently opportunities for victims. And of course, the judges want victims to be present as well. So I say that you only to say that it's not just lawyers.
The Prosecutors Association, the State Bar, almost every official justice group is opposed. But
go ahead.
With that said, Ohio has a really good victims' rights statute. It has no enforcement mechanism, nor does the new amendment that is being proposed. In fact, it exempts the government from any liability. I think victims should be notified. I think they should be consulted. I do not think they should have any control over the outcome of the case. The prosecutor sees a huge range of cases and has a much better understanding of where this might fit into the system in terms of whether this assault is a fairly minor one or a very major one, whereas a victim may, as being the person who was assaulted, obviously take it much more personally. We're here about public safety, and ultimately I believe that's what the prosecutor's trying to achieve, is public safety. Long prison sentences don't accomplish that very often. What we find statistically is anything over 10 to 12 years really has very little impact after that moment when you look at sentencing standards. But we tend to sentence people for certain crimes 25, 30, 40 effective life sentences, because what we're saying is that this victim, when consulted, wanted the maximum sentence and is complaining very loudly, and social media has given a greater voice to that. But we need to remember our justice system isn't based upon an adversarial victim versus defendant. It's about society and what society needs to be protected versus an individual. That is not in any way to try and diminish what happened to the victim. It's simply about the contractual theory that we live in. As people living in this society with the protections of the society, we also have some obligation then to participate in the justice system, whether it's as a victim or a witness or some other participant when called to court. And whether we have a say in that outcome, though, needs to be left to those who work in the system with regularity. They need to be consulted. They need to regularly be conferred with and notified about what's going on. If we have a failure in victims' rights, we need to give more resources to prosecutor's office to make sure we have those notifications, to victims' advocates. And I guess my one, if I can very quickly, the one place I see this failing regularly is when we find out that the victim regularly doesn't want as much. And I see it more commonly in very significant cases like death penalty cases where the victim's family doesn't want death. they tend to get ignored in those cases. They don't tend to have access to victims' advocates anymore. The prosecutor doesn't talk to them anymore. We regularly get calls in those cases. They're not common, but when they happen, it's always stunning to me how often, because they don't want what is perceived to be justice, that they lose access to support systems. And I think that piece needs to be addressed as well.
Dan.
In a second, I want to invite questions from any of you, live questions, not just on the remesh questions. But so if you do have a question, raise your hand, and either I or my colleague Julia Wang will work our way over to you. When you ask a question, make sure you stand up to ask your question. Make sure your question is a question, brief, to the point, all that stuff. But I do want all of your responses
And
on
you
this.
hold the microphone.
And we hang on to the microphone. You don't hang on to the microphone. I've had to wrestle it away from the judge before,
Yes, you
but this question about overreach and overzealousness on the part of law enforcement and the prosecutor's office, it needs to be addressed. It was the top concern in the folks in the room. We had, in fact, 81% of the folks in the room feel that it's a concern. So, Judge Donnelly, you go first.
I think this goes to the issue of which I've spoken with Judge Russo before. I believe in Cuyahoga County we have a culture of plea and release. And anybody that practices—
What does that mean?
When anybody that practices, and I invite the media, if you want to come and verify this, go to any courtroom on any day of the week and watch a plea colloquy. And if you see a felony of the second degree get reduced to a felony 5 or a misdemeanor, you can predict with absolute certainty what's going to come out of the defense lawyer's mouth after you accept that plea. Your Honor, may I be heard on bond? And then I hear a bond pitch that will allow that person out that day that he's entered the plea. Sometimes the prosecutor doesn't even object to that, and we take the plea, and the person is released and the case is over. What I worry about is that coercion that is inherently involved in that. Someone who may have a defense to present being told that, look, you can wait 2 weeks or 2 or 3 weeks to try the case and all the resources, but if you plead to this today, you're out. The only coercion that someone should feel to enter a plea agreement is the knowledge that they have a trial date certain where the state's going to be held to their burden of proving those charges beyond a reasonable doubt.
And that's your example of being overzealous.
Well, if something goes from an F2 to an M1, you question what happened. Did the information just change hands and they got a good handle on the facts? And why did it take so long to get to that point?
Saul, what do you think?
And
Overzealous?
then Ms. Ward.
Yeah, well, I mean, I'm an advocate of what I call, and the folks that work with me, I call it skinny indictment. I don't like, just a lot of, sometimes you have a child victim. You ask a child victim, what happened, daddy, raped me, did something bad, every weekend for the last 4 years. Do you know how many charges that can result from that? And what I advocate is, let's go back and let's put in, maybe the first time that happened, the last time right before it got reported, and some milestones in between. Maybe the child's 4th birthday. Maybe when the day that she came home for the Halloween party, and her daddy took her in and did something to her. So we're trying to come up with more of a what I call a skinny indictment. I know Prosecutor O'Malley has pledged to cut down on some of the and I wouldn't say they're stacked. It's just you have a like you said, rape with a kidnapping, and the kidnapping says that you restrain somebody of their liberty for the purpose of sexual activity, and if that merges, and as you know, Judge, if those had the same animus and they merge for sentencing, you only get a conviction on one count. As Ms. Ward and Mr. Young would explain to their to their client that you're looking at 3 to 11 years on the rape, as well as 3 to 11 years on the kidnapping, but we can make an argument that those merge, so you're really only looking at 3 to 11. So to say that, well, kidnapping and rape, that's an overcharging, it fits the crime. You restrain somebody of their liberty for sexual activity, that fits the same crime as rape, and we're allowed to charge that.
Can I respond real quick? Well, what about in a lower form of sexual assault, gross sexual imposition? I've seen it twice this year where they've attached the F1 kidnapping, the higher charge, which is ancillary, presumably based on the restraint of liberty on a gross sexual imposition, that only carries with it a maximum of 5 years. But if the jury finds that kidnapping charge,
life.
it's depending on the age of the victim, it's a life.
Yeah.
So you're making a gross sexual imposition charge, which is the primary, which the legislature has carried with it a 5-year maximum. And just by charging in that certain way, you're making it
And again,
a
Judge,
life
this-
sentence.
This is
That's a lot of leverage.
Your comment of overzealous.
And let me
But
just
Saul,
say.
I have another.
Well,
Answer that, but then I thought I'd ask you.
The kidnapping statutes, which I don't write, then come down from the legislature, also say that the restraining of the liberty and having sexual activity with a child under 13 carries with, you can charge that.
That
So
was-
it's not a baseless charge that goes along with it. So if you sexually assault a child under 13, expect that charge.
If I could, and that, I was just going to make that point to you. So you're the gatekeeper of because it's not only they're talking about overzealous prosecution, but also the investigation by police officers. But you're truly the gatekeeper when the police come in, right? You have the opportunity to look at the report and make that determination of, the police aren't coming to you and say, here's an F1 and here's an F3. You do that. You're the gatekeeper. Is there a check, or do you believe there's a check that you have over the police who are bringing the defendant and the accused down with their report to decide what those charges are?
Yeah, again, because you only see this, you don't see the bigger context.
Correct.
I mean, everything is, you got to look at the context of all of it. You don't see all the work behind the scenes, all the discussions back and forth, all the rejections sometimes of cases that, while we think something happened here, I just can't prove it. I don't know, I can't
Ms. Ward, you had-
sustain my burden.
You had something to say.
I wanted to address what the judge indicated when he mentioned a defendant's in court charged with felonious assault, but he's pleading to a misdemeanor, and then one of us is asking for bond. Now, first of all, if you do have an F1 or an F2 to a misdemeanor, there's a reason for that. There's no way we're getting a misdemeanor on a 1 or a 2 just because. But the case is obviously extremely weak. But explain to your client, listen, he's not getting out of jail because it's a high-level felony. You have an opportunity for a misdemeanor, you have the opportunity to get out, versus waiting exactly 3-4 weeks for a trial in jail. The reality of that is your guy wants to get out. I can talk all day long about the case is weak, we can go to trial, I've got an 85% chance of winning. Of course, I can't guarantee anything. You're not guaranteeing it. The guy wants to get out of jail. Now, that the issue of bail reform is a whole nother issue and maybe a topic for another forum, but the problem is because of the bails, which is another problem we have. But in reality, an individual that is locked up and has an opportunity to get out, they want to get out. And, I can preach all day long about winning.
And the prosecutor's
Ms. Ward,
office has been at the forefront of bail reform and trying to, we brought in experts from out of state and different foundations to look at our bail, because we really want to concentrate on, on the worst of the worst.
Well, and I'm glad you raised bail reform. That is a topic we've discussed here before in previous sessions, and I'm sure we'll discuss again. We now have a question from the audience.
This is a question for Assistant Prosecutor Awadallah, and I'd like the others to please weigh in as well. Does the prosecutor's office maintain a Brady file on police officers who have been accused of, found to have engaged in misconduct, including but not limited to lying and perjury? And does the prosecutor's office make that available to the public or decide when to disclose that information to defense attorneys? Can the public generally access that kind of information to discover what police officers or law enforcement officials the prosecutor's office has identified as potentially being problematic?
And what's a Brady file?
Well, the concept of a Brady file, and you see reform happening all around the country where local prosecutors' offices are now centralizing information that would, the idea of Brady being that you turn over evidence that would be exculpatory to the defense, but also in this instance, you could use to impeach a particular officer who's going to testify in a case. Perhaps they've been accused of committing perjury earlier in another case. And so I asked this question in part because I've sent information about problematic officers to the prosecutor's office and have always wondered what happens to it. No one ever responds, acknowledges it. Public records requests for Brady information have gone ignored. And I'd like to know what this prosecutor's office policy is. Do you have such a file? Do you maintain it? Can the public get it? Or just defense attorneys when you decide to turn it over?
Thank you.
Yeah, I'm glad you asked that question, Mr. Chandra. We actually are in active discussions, and we've had meetings about forming such a policy, and we right now it's more of a informal, and we tell, hey, if we have problematic officers, I mean, just, the other day we went up and dismissed 30, 40 cases on the East Cleveland bunch that went down, and did that proactively and in conjunction with defense counsel. But that's a very good question. I mean, we're charged with knowing everything in that file and everything in law enforcement's minds, and we demand them bring down the files. Sometimes we sit down sometimes and still. I tell my folks and myself that you can prepare as much as for trial as possible, but there's always going to be some surprise at trial. But you try to minimize those surprises, and one of those surprises would be impeachable Giglio issue with a police officer. But those are active discussions that we're having right now with regards to. I know other states, California, they maintain an accessible database, and that those are active discussions I believe that we're having.
So right now, no.
That's what it sounds like.
Yes.
Vicki Ward, did you have something you want to say about that?
No.
Okay. Another question.
I'm Teresa Stafford for the Cleveland Rape Crisis Center. You all mentioned Ohio Revised Code 2930 that outlines victim rights in the state of Ohio, also Marcy's Law. You also mentioned that neither one of these have any accountability factor built into them. So what, since you all oppose Marcy Law, are you all thinking about adding any accountability factors, or do you have any suggestions how accountability factors can be put in place? Because, if a victim isn't informed of a plea bargaining process and they are told after the fact, there's nothing in place to say, hey, she wasn't informed or he or she wasn't informed. There's nobody held accountable. There's no teeth in the law currently. So I would love to hear from all of you all about some things that can be put in place for us.
And to clarify, Marcy's Law would require that victims be present at all sentencing. Is that the...
It's much more than that. It's very, very driven, victim-driven, that things couldn't even take place. The justice system would slow possibly to a halt if a victim just didn't want to come. We couldn't find the victim. We weren't able to. So there are some factors. I'm sure Tim could talk more. But if I could, only because I sit on the Ohio Judicial Conference Committee for Administration of Justice as well. So we've written a letter to the legislature asking for the accountability in the current law. It can only be changed by the legislation, by those in our state. If all of you could become active in that to your state legislature, whether in the House or the Senate, to look towards moving that to some accountability in the current law. It may be the backdrop of if Marcy's Law doesn't happen, that the accountability of that moves to the current law that's in place now. And we've asked in a written white paper from the Ohio Judicial Conference about that to the legislature. So that's what the judges have done in the state of Ohio. And Tim, you're on the committee.
Really briefly, the difficulty with the amendment as presented specifically exempts the government from any liability for any failure to carry out any of these rights. Well, almost all of the rights have to be carried out by the government. There's this vague mention of the right of a victim when their rights aren't enforced to petition. I'm not sure what that means, and I don't think anybody else knows. Some people have said it goes so far as an appeal of the actual conviction. I think appeal is a different word than petition. Petition to me suggests a writ, and I don't want to get into what a writ is for the non-lawyers, but it's a special process to ask that somebody be ordered to do something. But I don't think it provides the protections that we're talking about. If you want rights for victims enforced, you have to have liability for not enforcing them. And you have to have funding available to those who are supposed to enforce them. So I think the statute we have is fine. It needs teeth and it needs funding. Liability when a prosecutor's office is shown Perhaps not just one time, everybody screws up once, but if there's a pattern of failing to notify victims, maybe you start imposing some liability against that office. That money out of their budget will quickly get them to conform. And you provide access so that they can actually have a full-time victims advocate in their office. But simply writing words in the Constitution and then saying, but nobody's liable for carrying them out, isn't anything but words in the Constitution. And by the way, it will be the longest actual amendment in the Ohio Constitution over any other, but it carries no teeth. And that's just simply words on paper, and that's not helpful to anybody.
Anybody else thoughts?
I understand that the courts and the public defender's office are against it. I think even the OPAA, but
Yes.
Our office is, it's on the November ballot, and we do so much with victims already. I don't know if it would be that much more onerous to continue. We work well with victim advocates. We have 3 full-time victim advocates in our office. Our whole system, our whole Justice Matters system that provides the discovery through the portal is designed to send out the victim impact statements, and we receive those, and we take those very seriously and into consideration. So I think Prosecutor O'Malley supports victims' rights and will support this amendment should it pass.
I want to ask you to address one question or a concern that came up through the audience, which has to do with racial disparities. Does the plea bargaining process adversely impact people of color in our community?
I think there's a perception of that, definitely. And that goes right to my...
There's a perception, but does it?
Talk about, well...
Yes.
Yeah. When I see a rape charge get pled to a felonious assault charge or an aggravated assault charge, and that individual who gets that plea that is most likely factually baseless, I wonder what the public thinks of that. For what reason? Is it because they had retained counsel? Did they pay enough to afford to get that baseless plea? I can hear what the victims advocates are saying. They're not getting accountability through some of these pleas. For many years, rape charges were pled to aggravated assault. The public doesn't know that aggravated assault has nothing to do with sexual assault. And I believe, it's not just the victim should be consulted. It should be explained to the victim what is the defendant being held accountable for before that plea is accepted.
It's interesting you took that towards the whether victims who are people of color are adversely impacted by this, but I think that there's the other point of view is about defendants who are people of color.
And I think
Vicki
I heard
Ward.
oh yeah from Mr. Young, like a home run. It was oh yeah.
The numbers are astonishing. I mean, they are beyond dispute. And what is so disturbing about criminal law is you have more rights to protect yourself against racism in your job than in your freedom in this country. We have these ideas, and you lose your job or you don't get hired because of racist policies or policies that are issued in a racist way. We have disparate impact and disparate treatment policies, and you can recover and you can get your job back. In the criminal law, only disparate treatment. Only if you can actually prove somebody held a racist belief against you, that they used that epithet, usually is what's required. But overwhelming statistics, and we have them every single step of the process. Black people are far more likely to get stopped when driving. If they get stopped, they are far more likely to get pulled out of the car and searched. Once a ticket is written, just for misdemeanor stuff, just little stuff, they're far more likely to receive multiple tickets for that stop than just a single ticket. So the officer will write a white person just the speeding ticket. For the black person, it's a speeding ticket. It's a no license. It's a your tail light's out. Your music was too loud. Your muffler was too loud. They get 7 tickets out of one stop. Once they process into the system on more serious charges, every bit of data we have says that black people get worse offers. They get worse sentences, they are far more likely to be revoked from parole, and they're far more likely to never get their rights back for voting and other collateral consequences when and if they can be recovered. Every single step of the process has overwhelming numbers, and I suggest to you, if police
behaved in the way in rich white suburbs that the way they police poor black communities, we would end our police departments tomorrow. Because the abuse that goes on in these videos that you keep seeing, everybody says, oh, it's just one bad apple. Please remember what the rest of that quote is. One bad apple spoils the bunch. I'm not saying all police officers are bad. Please don't hear that. But there has clearly become a very disturbing trend of how we police and how we arrest and then how we take those cases. And I'm not suggesting people are openly racist or even thinking about this process, but we all need to be very aware of implicit bias. The bias that we carry just from living in this country. Think about the terms we use. Things that are good are white nights, where you have all these white images, snow, these snow-covered mountains, all these peaceful images. When we talk about evil things, we talk about them in dark, we talk about them in black, we talk about them, and those are implicitly in our minds. You can't avoid thinking about those things. There are tests out there. I would encourage you to look them up. You can take to test whether you have an implicit bias. Most people do. It's overwhelming, and it invades our system every day.
Let me jump in. That's an impassioned statewide perspective. I thank you for it. From the perspective of a defense attorney working the courts every day, Ms. Ward, do you see this?
Yes, I do. It's evident just in if you look in any prison, not only in Ohio, but in this country. Mm-hmm. The majority of the inmates incarcerated, at least 85% are either black or brown. And it's there. And it's either through the it's either through the arrest, the plea bargaining process. As Mr. Young indicated, it begins from either being pulled over, being stopped on the street, walking down the street. You may have, young black men walking down the street looking suspicious as far as the police are concerned, are arrested. When pulled over, getting those tickets, Mr. Young forgot to add that the car is usually towed, which is another added expense sometimes, and the person goes to jail, the fees mount up, and then it's almost impossible to get your property out, and then it's forfeited. And so you've got this dual thing regarding class as well as race. And it's definitely prevalent. It's a fact that exists daily here in this county and all over the nation.
Saleh, Awadallah, do you share this concern?
It's a factor. I mean, unfortunately, I'm a big advocate of representation within the system. I mean, and you see sometimes public defenders can representation in the prosecutor's office of faceted, folks coming in from different backgrounds and racial and ethnic and young, old. But I don't know if we have, the representation on our, whether it's the judicial system, whether it's, our courts themselves, in common pleas. We're throwing a lot of rocks, and a lot of times, sometimes they're boomerangs, but because they will hit you upside the head. Because you throw something, you are part of the system. Whether it's a judge taking a plea, whether it's a defense attorney, up here saying, I took that plea, or I did not take that plea, we're all part of the system. We all have to be part of the solution. And I look at in our bench, and it's, it's not as representative as I would like. And that's the bench. And we talked about the immunity clause here, right? Up here.
Yeah. You're totally immune and absolved. We are going to wrap this up by going back to remesh, where there's a series of poll questions, and then the final question is going to ask you for your solutions that you would recommend. All of this stuff we're going to collect, email back to you so you kind of can see it for yourself as well. I just made that promise. Aaron, can we do that? We can do that? We can figure it out? Okay. So go back onto remesh.chat/justice. Get over there, and there's a series of poll questions, and the first one, and they sort of ask you how much you agree with a bunch of statements. It won't take very long.
Dan, I'm going to ask for those here in the front, if you just gather what I would say a 2-minute closing argument, That may be hard for you, Vicki, just 2 minutes. I've seen you in action in my courtroom advocating, but really, 2 minutes. You've all mentioned in some way in all of your responses ways that may, I'm not saying it's broken, but change, improve, make more efficient, justice in this process of plea bargaining. And what you might say to us needs to be done in Cuyahoga County, maybe larger on the state of Ohio, but Cuyahoga County, what can we do? What would be a suggestion for us to move forward on as stakeholders in Cuyahoga County to look at plea bargains and what you may feel to be inadequacies or efficiencies that we may need? So we'll pretend this is what, the Price is Right? Is that the bell going? Jeopardy. Thank you. Like you. All right, so think about it, and I'll let you run some of your...
Well, the poll questions are going, so, but you guys can, but we can multitask here.
Very good. We'll go with Vicki first.
Oh, great.
That way, when we get down to Tim, he'll say, well, Vicki said it all.
Yeah? What are your thoughts? So, again, put you on the spot.
Briefly,
What do you think we could do in Cuyahoga County? How would you direct somebody to say, if you did this, Judge, or you did this, Mr. Prosecutor, or you did, this would be helpful down the road?
I would like to see that a case, when we present weaknesses in the case and have evidence, facts, and what have you, that it's actually looked at and considered. Many times it's just not considered, and this is the plea bargain, and it's take it or leave it. And also, with regard to they rely too much on what the police officer wants. When the police officer is asking that your client get clobbered, but if the cop is saying, hey, cut him a break, it's not really considered as much. Also, I don't think there's much of a problem with victim notification, because in all my cases, the victims are notified. They're either there or they filled out the form, the victim impact statement, and the courts always make sure that the question is asked, was the victim notified? And 9 times out of 10 they are. So I haven't seen that as being any big issue. But I really think that the plea bargain process could be a little more balanced.
Okay.
That's what I wanted to.
Do you want to say anything?
No,
What's been?
no, it's okay.
Tim, I'll let you just wrap that around from the defense side, since both you and Vicki in different ways are here in different titles, but really do the same thing. Why don't you finish maybe or add to her thoughts?
Thank you. I really think the fix is back at the beginning. It's not at the plea bargaining process. I think you have professionals involved. It's that they're both sides, their hands are so tied. And 2 real quick examples. We've heard about this kidnapping charge and rape charge and that it's going to merge. Okay, that's true. My question is, does that sound like a kidnapping to anybody? I went to law school. Kidnapping required you take somebody somewhere. What happened was, back at the beginning of this process, our legislature has created this fallacy of kidnapping. The word is asportation, that you have to asport somebody away from the scene of where you found them. Otherwise, it's just illegal restraint. That's it. So we end up with this double charging because the legislature has handed this tool to prosecutors that's just not legitimate. The model penal code, most states don't have a kidnapping statute that doesn't require that. So when you're talking about, oh, I'll drop one charge and you plead to one, I'm kind of missing the bargain in the plea bargain. It was going away anyhow, and it really wasn't a crime in most places, at least not as defined, and not where you could get somebody an F1 life when you didn't remove somebody. That's just one example. Another very minor example, for years, pot in this state has been a minor misdemeanor. The bag you carry it in some places, can be considered a 4th-degree misdemeanor. So instead of being charged with just minor pot possession because a prosecutor wanted some time out of the case, they charged you with paraphernalia. Pretty sure they weren't talking about the baggie you were carrying your pot in, but we've allowed that to happen. And so we've got this broken process from the beginning where we have really lost our way with our legislature in terms of the ability to overcharge that is now being used dramatically. This sounds very, very strange, but you want to fix this? You fix gerrymandering. You get real debates back at the legislature, not a place where you have 75% supermajorities in both houses and they're no longer debating what the law should be, but they're debating how not to have a primary challenge. That's really what's going on in our State House today. And you can't fix this until you fix that. And that sounds like a big jump, but I think that's where you have to start.
Dan, your next topic, gerrymandering, right here. We'll bring it here.
It's been a topic many, many times.
So, how about yourself?
We're here to talk about the plea bargaining
Yes.
and you know the comments about the fix from the beginning. Again, that goes back to the legislature. That goes back to us voting. That goes back to us taking an interest, you know, in our system as a whole. That's what democracy is all about. Take it or leave it. You know, take it or go to trial. Put your faith in 12 people, and you know let the chips fall where they may. I would personally would rather see more trials than pleas. The plea agreements come about as a result of both sides coming together and understanding the strengths and weaknesses of each side at that particular point in time. I might have a great case yesterday because my victim is available. Today, she might be in Hawaii, and the judge is calling for a trial right now. That may be why an F2 goes down to an M1. Or I could just dismiss it and just re-indict you, you know, when she comes back from Hawaii. But you choose, you know what, I'll take that bargain at this particular point in time. The other thing I would say is, you know, I have a healthy respect for the defense counsel and our defense bar in this county, but they're vastly underpaid per case that they take. I mean, yes. the most improvement I would see in the criminal justice system is to see a very vigorous defense. You know, put me to my test. Make my job that much more difficult by poking those holes. You'll get the benefit of the bargain. We'll take it to trial and we'll have 12 people decide.
Let me just interject really quickly to say that we're at that final question now, asking you for your solution. So if you've been holding back, just jump in now, please. And Judge Donnelly, 50% of the folks who are participating believe that you've got a great idea there about factually baseless pleas, that pleas ought to have a factual basis. You've got 50% here. I just wanted you to know that.
Well, thanks. It makes sense because
I'm going to jump into just looking at the clock and everybody's here. So you want to tell us, what do you think? How do we improve it? How do we change? What are your?
I think that the statistic means something because most people want to believe that we're here to get at the truth, and then once we arrive at that, we can decide how we move forward with these cases. We've heard a lot of issues tonight. What I would love to see generated from this is a task force statewide where we bring all the stakeholders together. Everybody that's here tonight, and something that was said, prosecutors have a lot of influence with the legislature, the Ohio Prosecuting Attorneys Association. If they were to go and say that the catalyst for these factually baseless pleas are the draconian sexual registration requirements, that might get them to move and start going to a more evidence-based process where judges have discretion, prosecutors can go before and say this person needs to be registered, and the defense lawyers can contest that accusation. It's not a justification to let the process keep going. Second, the equipment, the system is not equipped to deal with the reality that people are wrongfully convicted in this system. And to get your case back before a tribunal, to argue your case, that maybe the evidence that was used against you isn't correct, whether it's scientifically unproven or whether it's someone is recanting. Right now, the system's not set up for that. Judges can rule on motion. They're not even required to have hearings. And sometimes when they have hearings, prosecutors offer pleas to people they've already convicted and exhausted their appellate rights. No one's questioning that. Is that a good process? All these issues could be hashed out over a year, and we could move in the right direction and improve the system. I think it's an obligation on all our parts to do that.
Very good. Thank you.
All right, we're going to wrap it there. The results of the remesh activity and all of your contributions, we're going to compile that into a blog. We will email it out. You'll receive it at least 8 times from us, and then another 8 times from the Bar Association. I want to thank our panelists, Judge Donnelly, Tim Young, Saleh Awadallah, Vicki, and Vicki Ward. I want to thank our moderator, my co-moderator here, Judge Russo. Please give them a round of applause. And let me just remind you that tonight at the City Club, we've been enjoying an Anatomy of Justice forum on the mystery of plea bargains. This forum is our annual forum on the American justice system, endowed by Robert J. Fay, Myron Krautinger, David I. Sindel, Paul W. Walter, and Jesse Glassman in memory of Samuel Glassman. We're delighted that Darrell Clay of Walter Haverfield is with us today to remember them, and we thank you for your continued support of City Club programming. Our community partner and our programming partner today is the Cleveland Metropolitan Bar Association. Additionally, we welcome guests at tables hosted by the Cuyahoga County Office of the Public Defender, the Cuyahoga County Prosecutor's Office, Judge John J. Russo and Judge Michael P. Donnelly, and the law firm of Thompson Hine. We thank all of you for being here today, for your support, for your assistance in helping us plan today's forum, and that does bring us to the end of the program. Thank you, panelists. Thank you, Your Honors. Thank you, ladies and gentlemen. Thank you, Remesh.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.